Beautiful, beautiful people. As always, welcome back. Let's go over something real quick to reiterate some truths and fact as previously mentioned, because there's absolutely nothing more worse than having an information without comprehending the scope of how and why it works, which is always constantly reiterated in this channel and other platforms. You will see where people say, sue them, 18 USC 241, 242. The past videos have been made and the fact that 18 241, 242 does not afford you a private right of action because you are generally perceived as a private man when they want to abate liabilities from you. In other words, if you're a private man, that means you need a private contract with them. Yes, they swore an oath to the Constitution, which is the predecessor of any contract as it relates to how they will interface with you if they are public entities. Most aren't even aware the Constitution isn't applicable to private entities because of the rights and obligation of the contract and the intent as to how those quote amendments, which are the quote Bill of Rights on a federal level, how they even came by. If people knew how those things came by, then they would comprehend why and how it's inapplicable to private entities, but nonetheless can be binding if rights and obligation of contract were evoked, and how the Bill of Rights is tethered to the difference between how, quote, governmental entities or public entities are presumed to be, regardless of whether they get their funding from private entities or they contract with private entities like you would outsource a business for the purpose of limiting liability. Those are other situations, but if you're dealing with a public entities, then yes, the Bill of Rights and Constitution applies because that's what it's meant for. But when you start going into suing people using 18 USC 241, 242, what is the intent behind the creation of an existence of 18 USC 241, 242? And what is its applicability? What is its scope? What is its exception? And what is its admissibility? No different than the rules of evidence. No different than when people speak about objections. Most don't know there are 19 different types of objections. And when they sustain or overrules it, based on the type of objection that they bring forth, you are supposed to say something, not that you take exception. You were supposed to say something based on a different type of objection so that it will not be overruled or sustained in your disfavor. Even right then and there, even if the acting judge sustained their objection in a manner that does not favor you, if you know the type of objection and the counter to it, you can flip that around and the acting judge will overrule it rather than sustaining it to your detriment. But do not deviate too far. Here it is again on the note of 18 USC 241, 242. Nothing is more dangerous than having an information and not knowing what it is applicable to. As always, in the rest of the card that's shown here is not to say someone is bad or good. It's just to show that you ought not to fall under the same category. As always, in the rest of the card that's shown here is not to say someone is bad or good. It's just to show that you ought not to fall under the same category. As always, in the rest of the card that's shown here is not to say someone is bad or good. It's just to show that you ought not to fall under the same category. Case law we're looking at is Abdullah Bay versus Attorney General of Massachusetts. It's titled Attorney Gen. of Mass. So let's get to it. Plaintiff's allegation provide a basis for federal question jurisdiction under 42 U.S.C. 1983. When they say it provide a basis, this basis is based on res judicata, whereby they look at what you write, independent of what you put on pen and paper. They look at what you write and look at it based on the easiest path to interpret it to your favor. So make no mistake, when they use this term basis, there's actually a formal definition, a legal definition for this word basis, which is basically whatever it is you putting down on prima facie, meaning on its face as we're looking at it, what's self-evident. There's something more to it, and that something more to it is what we're going to look at rather than what's on its face. There are different standard of elements. There's prima facie, substantial evidence, probable cause, which, by the way, probable cause in criminal claim is an extremely low standard of evidence, which will be found in the Constitution. Now, on a criminal level, as we went over in Patron, an evidence beyond reasonable doubt is what you want to look at in the criminal level. On a civil level is preponderance of evidence. So there's standard of evidence in their hierarchy. prima facie and probable cause are very low ones. And when they use this specific term basis, it's based on the standard of evidence, where they compare what's in on its face, aka prima facie, which is standard of evidence, compared to what is beyond it, what the intricate intent is. So they're not saying with this first clause right here, they're not saying that this is what the man or woman brought. They're saying the basis, which is the core of what they intended to bring, is under 42 USC. And in other videos, we've run over 42 USC. Publicly here on YouTube, we run over the fact that 42 USC has to be tethered to a Bill of Rights because it's not self-executed. And it's tethered to some other things, and its applicability of what persons is and how it came to be. We've made about 4 or 5 separate videos showing those details here. On YouTube. On Patreon, we went over the intricate details of standard, test, and elements of 42 USC and other things, other tort claims that has to be attached for 42 USC 1983 to suffice as a claim that will not be subject to a dispositive motion like a motion to dismiss. But nonetheless, plaintiff's allegation provides a basis, meaning the core of it, beyond what's written down. A basis for federal question jurisdiction under 42 USC 1983. Section 1983 supplies the cause of action for an alleged federal constitutional violation. In other words, in order for you to state a federal claim, aka a federal question or original jurisdiction, you have to invoke some type of federal related public law or the root of those public law, which is the Constitution. And in this case, they're looking at the core of what was written down in whatever petition, complaint, bill, whatever it is. And they're saying it's actually 42 USC, 42 USC being civil in nature. And by the way, there's a counterpart to original jurisdiction, which is usually very important for you to comprehend before you bring claims on a federal question, on a federal level. We go over that on Patreon. Although Bay states that he brings this action pursuant to 18 USC subsection 242, the provision of rights under color of law. Let's read that again. Although Bay states that he brings this action pursuant to 18 USC 242, the provision of rights under color of law, meaning what was written down prima facie, was a criminal stipulation. In this video right here, we went over what 18 USC 241, 242 is in comparison to any civil claims or anyone who purports a criminal claim, a charge against other people. You see many people do all these fee schedules, 18 USC 241, you charge this, violation of that. Do these people know the core of the intent of the legislature behind 18 USC? Its origin, its applicability, its scope, its exception? It doesn't seem like it. In this video, we also went over the foundation of what private rights are and who it's applicable to and not, as it relates to good old 12b6 brick. So it would probably be best that these 2 videos be watched first or after this for you to really get a core comprehension of it. But nonetheless, the summary is 18 USC is applicable to criminal charges, 42 USC the civil equivalents of the criminal charge in 18 USC. And in this video right here, the Patreon page, we run over the core details of who it's applicable to or not. But here on YouTube, here's another extra thing, which is clearly written on its face. If you're still not clear yet, if you're still hanging on to 18 USC without knowing how to bring a grand jury, most people are stuck on the issue of trial by jury versus jury trial. When in truth, that's the wrong perspective to even be stuck on. What you need to be focused on is, what is a grand jury compared to a trial by jury? If you ask most people who talk about knowing about one thing or the other about rights, and you ask them, what is a grand jury and how is it used? They don't know. They do not know. And these same people will be the people that will put 18 USC 241, 242 all over their documents, sign a bunch of res judicata about criminal claims, but do not know how grand juries function and how grand jury is tied to the First Amendment right of redress and grievance and the right of, quote, we the people, as it pertains to bringing criminal claims. That is a huge cause for concern. And this ought to be an eye-opener for you. No one is saying that what's being done by one party or the other is wrong. Change is the only thing constant in reality because lessons have to be learned. Sure, you've heard that saying, change is the only thing constant in reality. Well, it doesn't end there. Change is the only thing that's constant in reality because a lesson constantly has to be learned. So when these things are shown, this is not so you could go now have the right to go talk some trash about someone or to feel like someone is speaking ill of you. No, it is to enlighten you to that which you were once ignorant of. And the issue with most people is one of the primary algorithms that's been embedded into the operation of reality, which reflects in their own innate nature as an intelligent sentient being, that being changed and lessened, they don't like it. Whenever something is introduced to them that says, hey, maybe you probably learned the wrong thing in the past. You've probably been misled by someone who explained something to you and you trusted them or you respected them, which is fine. But maybe they did, in fact, recognize the information properly, but you did not recognize the information properly. And you misunderstood something in transition based on your level of development. When someone now introduced that to you, in this case being the 18 U.S.C. 241, 242, does not give you a private right of action. And most importantly, there's a specific way to evoke it because there are certain limitations to it, which we go over on Patreon on how to do so. Take these words, heed these words, and evolve, learn from them. Do not remain on a level of stupor. Do not remain on having a huge will, a huge fire, without any ability to control or navigate that fire with competence. It goes on to say, although Bay states that he brings this action pursuant to 18 U.S.C. 242, meaning this was what was clearly stipulated on black and white, the provision of right under color of law, 42 U.S.C. being the civil equivalence. Listen to this. See docket number 6. The statute does not provide a private right of action and cannot be used in a civil action. This was the same foundational principle that we went over in this video and the rest of Carter in this video also, regarding the fact that a private right of action, which cannot be brought under 18 U.S.C. 241, 242, and it was adjudicated in 1985 as shown in this video. This is another one in 2001. These rest judicators have not been overturned. The question you and others listening to this, or that will be eventually finding this out maybe sometimes down the line after they failed or as they're preparing for something, is why is it that 18 U.S.C. 241, 242, which is a criminal claim, why does it not bring or invoke private right of action? These are the questions people are not asking. And it's unfortunate that 9 out of 10 people who speak about, hey, sue them, 18 U.S.C. 241, 242, the provision of right under color of law, 9 out of 10 of them will never figure it out. We go over on a Patreon. But nonetheless, if you watch these other videos, you'll be able to put 2 and 2 together. That's why they're being uploaded on YouTube. The statute, that being 18 U.S.C. 242, and its subsequent sections, does not provide a private right of action and cannot be used in a civil action. And then they even give you a little bit of hint, stating that only the United States' prosecutor can bring a complaint under 18 U.S.C. 241, 242. Do you know the reason why the United States prosecutor is the only one who can bring this claim under 18 U.S.C. 241, 242? That reason is clearly given to you also in the Constitution. It's in the 11th Amendment. Although the Bill of Rights is just the first 10, but within the 11th Amendment, they tell you. Now, whether or not people have eyes to see or not, or comprehend intent. See, most people who read these Bill of Rights and quote unquote their rights, they don't look at the intent of legislature. They just read it on its face and just take it for prima facie and run away with it. When you look at this specific 11th Amendment that we're speaking of here, it took place in the year 1795. This is the reason why I'm using this version of the text to actually show you the year that this was ratified. So the whole contention of 1933, 1871, all that stuff comes later down the line. The concept of sovereign immunity was long introduced a few years after the Bill of Rights, which is the first 10, were introduced. So don't get it twisted. Don't get it confused. Read the intent of legislature. It's in the Library of Congress. Everything has been digitized into a record now, so there's no need to spoon feed you on the intent of legislature when you can go look at it and read it word for word. But moving on. Amendment 11. We're not saying this is right or wrong. Have you ever heard of that thing called sovereign immunity? Do you know that 11th Amendment is its origin? Judicial limits. The judicial power of the United States shall not be construed to extend to any suit of law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subject of any foreign state. Believe it or not, in summary, this is exactly what sovereign immunity sounds like, and the operation thereof sounds just like this. That only the United States' prosecutor can bring a complaint under 18 U.S.C. 241, 242, meaning you cannot sue us criminally in our court without using someone who is a shield, aka an esquire, of our commercial interest, who has a hold harmless agreement called their bar attorney number. This is the limitation they bring in people. The question people ought to ask now is, okay, so you telling me I can't sue anyone criminally unless I use one of theirs because of some sovereign immunity doctrine? If you look into the origin of sovereign immunity doctrine, specifically as entertained within the Martin P. Burke's Action at Common Law, you can either get the second or third edition. It clearly lets you know what the solution to that issue is. And in short summary here on YouTube, without all the details, is that you have to use the First Amendment right to grievance and petition by way of power of we the people. When people speak about we the people and they want to invoke that power, that's the power to bring criminal charges. But most don't even know that. So publicly they'll present this blockade to you, which would act as a form of loss of hope. But that's not the limitation of it. But before you even know where the solution is, you first have to be able to recognize that the problem exists. Most people are not aware that the problem exists at all. It is mind-blowing when people valiantly say, sue them, 18 U.S.C. 241, 242. That's a criminal charge, the provision of right under color of law. That will and fire is well and good. But do you know its applicability and its exceptions? And do you know the proper way to do so? That is the problem most people are facing. You be an exception. When they say knowing your rights involves knowing how to enforce it, or having a right involves knowing how to enforce it, this is what that means. Merely knowing something prima facie that's in black and white does not mean when it's crunch time, when it's at the heat of the moment, that you putting that black and white in a piece of paper and throwing it into a court file, it does not mean it would work for you. There is something called legal aspect, called operation of law, which many people run away from. They say what's lawful cannot be legal, when in truth, legal is just the operation of law. According to all these law dictionary people read, legal is just the operation of law. And if you look at the legal aspect of these things called your rights and criminal charges, you will see clearly the legal aspect, which is the operation of how to express, literally express on a piece of paper, that law that preserves the substantive right that you're trying to enforce within said Bill of Rights. People deal with half information and people half-step things, and they create rest to the cotters over and over to the detriment of the future generation. They mean well. And this is not just the only example. We've been shown many examples in the past, and we'll keep showing it. But do know that there is a methodology to everything, and you have the liability to know it. As it's always said here, liability compels performance, and where liability does not compel performance, value does. Value does. Most people don't realize everything they do on pen and paper with suing people or creating some type of obligation where they want to tether someone's mind into something to perform. They don't realize all that is just contract. And when they say they do, they don't comprehend what makes up contracts is really ultimately twofold: liability or value. Most people forget that they have to bring value to the table to make things work. Most people only focus on liability because they are so stimulated by what tort is being done wrong to them. And even if you ask people what is tort, they won't be able to tell you the specificity of what a tort is relating to their circumstance. Tort is so vast that you can have, for instance, assault. It's not what people think. We went over more detail on Patreon, but a little bit here on YouTube also. Assault is just the reasonable apprehension of battery, which you realize when you bring assault, it always goes hand in hand with battery. And if not always, then 9 out of 10 times, majority of the time, if not always. And another thing relating to bringing a claim without being buried to some limitations, such as USC 241, 242, where it comes to tort, is that tort has civil part to it and tort has criminal part to it. That same assault and battery can be brought on a criminal level just as much as it can be brought on a civil level. Merely just writing things down on a pen and paper just because you read it and it fits your circumstance is not the end. It's not even the beginning of it. The beginning of it is knowing what the applicability is, knowing what the scope is, knowing what the exception is, and knowing how you can make it admissible as evidence by knowing the standards of evidence and the 4 stages of evidence. The standard of evidence, we go over in Patreon, 4 stages of evidence. It's here on YouTube. Know these things beyond what you've seen someone speak about valiantly. Stop creating res judicata against people in the future. Till next time, take care, best of luck. I have a Patreon page and I'm inviting you to come join. Whether you're interested in discharge, we show everything about how it's done and my own experience. Consistent posts are made explaining many things regarding said discharge. Many will seek and simply wouldn't find. Those dealing with mortgage issue or want to know more about it, we speak of it. For those dealing with basic stuff like traffic issues, we speak about the solution, and I show it from my own experiences and how I permanently prevent any such issues. Those worrying about trust, different types of trust, we go over so many things consistently regarding trust. We show the IRS manuals. Those who are interested in suing and making money through debt collection or other means, we go over it. We show it. I show my own settlement checks and the things that I've done as a personal experience. Those interested in banking, we show subtle details and intricacies of the things that I have learned. For those interested in other things like the IRS forms and how to put it to use, we show it, explain the details. For those interested in court-related matters and intricacies, we always show it. For those interested in the spiritual aspect of things and how it works, we show and explain it. Those with child support matters, we explain and we show everything in detail also. Great puzzle pieces that can never be found in other social media platforms, but we explain it all as it relates to many different things. For those interested in express trusts and the issue of how not qualifying for taxation, which I call dinking, how it relates to any other type of trust or any other affairs, and how you can intertwine your affairs into the different types of discharge that exist and lack of qualification for taxation. Speak about it. The truth about really recusing attorneys and the whole foreign agent registration and attorney lawyer number, we speak about it. Speak about how to really bring about juries, and some of the comment section asks good questions and greater answers are given. Speak about how to get and use tax exemptions for vehicle use and sales. You don't have to belong to some organization. You can actually get yours according to the language of the legislature within your state. Go over the details that a lot of people mentor about regarding Article 1, Article 3. What really makes a court? It's not limited to just your paperwork. Most people don't know. We go over business matters for those with actual businesses, S Corp, C Corp, LLCs, those who are business minded and those who make monies. Go over other things that a lot of people don't know, functions internationally. We speak about a lot of other spiritual related matters. Details on how to bring criminal charges, what it truly means to bring criminal charges, what a bill of particulars is, how to recuse a judge, details of the parliamentary rules in court and legislature, different things about standard of evidence and burden of proof, different things that a lot of people will speak of, discovery. But did you know there are 6 types of discoveries? You know how to intertwine your LLCs and S Corps with an express trust, how to not make them taxable? Do you know when Trinity versus Pagliaro really is involved? Do you know how to use your home as a home office? And the many details involved. Go over the injunction and how to enforce the different types of injunctions that exist. The intricacies of how data brokers exist and how they steal information. Not just the credit bureaus, but many data brokers and how you can prevent them. We go over grants, getting grants. We go over issues and solutions of CPN and how they're created. There are about 4 to 5 different parts that were created. You go over caveats where people say sue them, but they don't really know. You go over the things to do after you sue them. You go over the issues of privacy and technology. The whole thing about perfection of security interest, UCC, and how to use it and how to monetize a birth certificate, all that. We go over the details. There are a lot of principles and doctrines people don't know about that we go over. Go over how to really do the copyright and the details involved in it. Go over how to simply do a trademark. It's far more easier than you think. All these people telling you go to a trademark office, do this, write this letter. It's not that difficult. Go over how to fill out the GSA bond box at a time, and so many more. How to get settlement checks, how to put your vehicle in a trust. I show you from my own experiences, form for form, step by step. Go over the different types of relief to be granted. The type of relief you seek invokes the type of jurisdiction that you fall under. All these people speaking about chancery, equity, and law, common law. The relief that you seek is directly tied to the type of jurisdiction. Go over the CPN, how it's created. Go over how to obtain bonds, where to do it. Go over the different types of discharge and some more. We explain each of those types of discharge. We explain how trademark and copyright is affiliated with asset protection. We go over how to prove trust. We go over the different types of fraud. We go over the importance that many people would never know. So many more. I show my own experiences in the audio calls from court cases of how I get different types of settlement checks. Go over the different types of discharge. There's so much more that it can't even completely be spoken of here regarding trust. We go over how to create it step by step, and many more things that will never be shown on YouTube or any other platforms. Go over other principles that people don't know about. When they speak about statute of limitation, well, fraud does have a statute of limitation, but do you know how to subvert it? As to why that phrase fraud has no statute of limitation to bring it to life, most people don't know. There's so many things that we speak about. We speak about how to garnish people's checks and people's property. There's a form that you use for that. People don't know about it. Speak about details regarding foreign trustees. Speak about spiritual related matters. And on the Instagram page, if you get to join, come on over. There's also a Facebook page where questions and answers are posted and other reminder links to certain videos are shown. Until next time, take care. Best of luck.